another thorny issue.
Yes. Good morning, Madam Chair and members. With me are, first of all, the principal of Dixon High School, which is a small high school district in my senatorial district, Nick Giaramonte, and he will be the main witness. And also with me is my legislative director, but also the vice president of the Dixon Unified School Districts Board of Education to talk about this issue. This is a small district issue. Right now, the custom and practice in larger school districts, this doesn't enter into their concern because they are large districts. So this has to do with the 131 districts where this is a problem, and I'll describe it now. In 2003, I authored a bill, in fact, it was my first bill on student hazing. The legislation was unanimous and bipartisan and signed by the governor. It allowed school district administrators to suspend or expel students who participated in violent acts of hazing against their fellow classmates, even when those incidents occurred off campus. Today I'm coming to you, actually probably my last education bill, with another bill which involves protecting students. And it also comes from a small district, in fact, the same district. 1343 would allow administrators and school boards to involuntarily transfer students who are convicted of a violent crime against another student. Today, districts with multiple high schools can already do this. They can involuntarily transfer students for a variety of reasons, including student safety. Districts with only a single high school, however, are not given that option. As I said, custom and practice in larger districts, this is what occurs. But Dixon ran into a problem, and that's why I'm here. Small districts are in a very difficult situation. For example, if two high school students are at a party over the weekend and the girl is raped by a classmate, under current law, he can return to the same campus, even the same classroom as his victim. This would also apply to students who are convicted of kidnapping or attempted murder of another student. Convicted. Understandably, this situation can make a victim very fearful of a repeat attack on campus and opens the school district to increased liability. In 2014, there is case law here. Clovis Unified versus Nathan G. held that involuntarily transferring a student doesn't infringe on the student's right to public education, does not infringe on a right to public education. Options for involuntary transfer might include continuation schools which offer diplomas, and a more structured setting for students, independent study, or college courses. This is not, therefore, it is not double jeopardy. Further, Section 28, Article 1 of the Constitution guarantees that a student has an inalienable right to attend campuses that are safe, secure, and peaceful. And in a case, again, in 2005, Danielle S. versus Ezra C., the court ruled that a student's right to attend a school is neither absolute nor unilateral, and that only a total deprivation of a state-given right to education would violate the Constitution. In this case, the court reiterates that there may well be cases in which the circumstances surrounding a single act of violence may support a conclusion that future harm is highly probable. This bill, 1343, will keep students safe at school and allow administrators and all school boards the option to involuntarily transfer students when issues of student safety are present. Those two cases are the case of Clovis. The issue is that these are not codified. So when you get to the situation here involving small districts, transfer to a like school became an issue. We need to correct that for the smaller school districts. Again, this is custom and practice in large districts already for, in fact, things that are even less than convicted crimes. So Nick Giaramonte, who's the principal of Dixon High, and my ledge director, who's also the vice president of the school board, is not going to testify, but she will answer any questions that you have. Nick.
So I'm here today to provide some local context and how this plays out on the ground for us. Many one high school districts are located in small, if not rural communities. In towns like ours, the lines between what occurs on and off campus are blurred, especially from a student perspective. Of course, the legal lines are not so blurred. We can either prove a nexus to school or we cannot. If we cannot, as is the case sometimes, we are left with limited to no options with regard to intervention. Our most important task when we have a violent act occur, be it on or off campus, is rehabilitating our school community and frankly our community at large as efficiently and effectively as possible. To do this, we need another option. It is obvious that the victim suffers if compelled to remain in the same school as a student who assaulted, raped, harassed, or committed any other type of violent crime against his or her person. In order for students to learn to their highest potential, they must do so in an environment where they feel safe and protected. Sitting next to their aggressor, passing that person in the hallway, attending the same school activity, playing on the same athletic team, these do not allow for this feeling of safety. In our community, recently, we had an off-campus incident which resulted in an assault conviction of one of our students for a crime against one of his classmates. As we were unable to prove a nexus to school, we had neither reason nor mechanism by which we could intervene with the aggressor. Furthermore, as the students had some of the same classes with each other, we ended up moving the victim's classes at parent request. As a result, the victim not only suffered in the assault, but also in his schooling. I ask you also to consider the aggressor in these cases. Students who commit violent acts are usually in need of intervention we eagerly apply whenever possible. However, for events which occur off campus, there is no way we can compel these students to participate in interventions such as restorative justice or counseling. If we have at least the option of an involuntary transfer, we are much more likely to get student and parent buy-in to interventions which do not involve a school change. But without this option, we lack this leverage to get our students to participate. I would also remind the committee that this is neither a suspension nor an expulsion. This does not double jeopardy. This simply allows schools and districts another option should the safety and well-being of students be compromised by off-campus events. Thank you.
Thank you. In support of the bill.
Laura Preston, Association of California School Administrators, we support. We would just like to add one more thing that it's in our letter to the committee, is that we do think the situation that has occurred in the situation you just heard about is very, very real. We also think that the student has a right to be told that they're going to be being moved somewhere. So we would encourage an amendment being added to the bill that would require the principal to meet with the parent or guardian and the student before they place the student in another location.
Okay. Any others in support of the bill? Any opposition to the bill? Okay.
Thank you. Appreciate it. Good morning. I'm Liz Guillen with Public Advocates. I really appreciate your forbearance. Unfortunately, and with respect, Public Advocates is opposed to this bill, and we have stated so in 2 different letters to the author and the committee. Just to be clear, this bill would allow a school district to transfer out of their one high school any student who's been convicted of certain felonies or misdemeanors for behavior out of school. And we think that this will have a disproportionate impact on low-income students, students of color, immigrant students, and other students with special needs. This is a very large population of students which is already experiencing many barriers to succeeding in school and graduating high school. It is clear that the bill comes from one situation in one district. The district's response is to find or create a legal way to exclude the student. There is a reason why the district may feel they have no options, such as restorative justice. That's because the student hasn't violated any disciplinary rules yet. He's simply come back after serving his sentence or being on probation. He's come back to resume his education, and frankly, he has to come back. California is a compulsory education state. The Constitution recognizes education as a fundamental right, and this is a barrier to obtain that right. It's a one-size-fits-all approach that will result in disrupting the student's schooling and other students' schooling. And it flies in the face of the recent work that the Senate has done to try and make the transition from the criminal justice system back into our public school system. For these reasons, I urge the committee to vote no.
Thank you. In opposition to the bill.
Good morning. My name is Lily Chen. I'm a staff attorney at Public Counsel, and along with my colleagues at Public Advocates, the National Center for Youth Law, Legal Services for Children, the Pacific Juvenile Defenders Center, and the East Bay Community Law Center, which runs all clinics at UC Berkeley Law School, we respectfully ask for your no vote on 1343. We support efforts to make our schools safer and more welcoming for all students, including victims of crime, but excluding students who have been convicted of a crime will not work to accomplish this goal, and will only increase the chances of that young person recidivating. The courts have existing methods like restraining orders and stay-away orders and are the proper venue for decisions about victim and offender interactions, not school districts. Determinations on restraining orders and stay-away orders take into consideration all relevant facts in a court of law, and those facts won't be available to a school district. The legislature has done much laudable work in recent years to support the reentry of system-involved youth, and this bill would undo much of that progress. Therefore, we ask for your no vote.
Thank you. Any others in opposition to the bill?
Madam Chair and members, Kevin Baker for the American Civil Liberties Union. We appreciate that this is a well-intentioned measure, but unfortunately we believe it's excessive and will have unintended consequences. Thank you.
Thank you. Well, any questions from members? Senator Mendoza.
I just have a few questions. I understand the intent of the bill. I like the bill in a way, but I just want to come back to one of the witnesses to see if, just to get clarification. So you were mentioning that the way the bill is written, that any student that has been convicted of a felony or whatever that's coming back to school can be taken out of the school and sent somewhere else, or is it based on if the student that was, I guess, the reason the student was convicted, if the other student is still at that school site? How do you interpret this? The way you said it, it seemed like you were interpreting it as that any kid, whether the other student was at that campus or not, can not be returned, can be sent somewhere else.
My understanding of the bill is that it applies to, in a single district, single high school district, to students returning, having been convicted of certain misdemeanors and felonies, whether they were convicted, whether the actions took place on or off campus, related or not related to school. My understanding is that the bill does not speak to whether or not the victim was on campus, or I haven't seen that language or recall that language per se.
I just want to be clear on that. I just want to make sure that it's because the victim is actually on the campus and the student is coming back, and it's going to create some sort of.
Yes.
I just want to make sure that is clear. I don't want it to be just any kid that's randomly just kicked out because of, right? Just want, because it sounded like that what you were saying. I just want to make sure that was clear.
Do you want to?
Yes. Identify yourself first.
I'm Catlin O'Halloran, and I'm the Vice President of the Dixon Unified School District Governing Board. We amended the bill about a week ago or so. I don't have the version in front of me to clarify that exactly, that it's against a student who is on the campus, right? So it's one student who's going to school who's the perpetrator, and one student who's going to school who's the victim.
Okay, and along the same lines, Madam Chair, and maybe you could clarify even further. What if the victim graduates and leaves and the perpetrator is actually now it's a lower grade? Can they be returned to the campus once the victim has left?
The bill doesn't currently address that. We could certainly work on.
I think once the.
I think that's so I certainly think that would be the intent of the bill, but it doesn't specify that.
Then that would help, I think, if you would add that as we move forward, just to make sure I don't, and I know these are smaller districts, so I'm not too familiar. Are there any such thing as non-public schools that you guys can work with or around your area?
The principal can speak to that.
It's, for our district specifically, that's the only one I can speak to. That's usually for special education students who require more services than we can provide in the local context.
Yeah,
So no, in this case, no.
in this case, no. When you anticipate sending this student to another school, do they have to accept them, or they have to just, they're on their own to try to find a location?
No, there's a process.
Certainly, if we were going to do an involuntary transfer, there would be a process, and this would be a district within our school district, so they would be required to accept the student.
The other school district would be required, you would work that out?
The other school would be within our school district, just not the comprehensive high school.
All right, will there be an ADA difference of any kind, or does it matter?
It would be a continuation school, or do you have a community school?
We have both, and I think the way we would interpret this is that we would work with the aggressor in this case, or the student that was convicted, to really find the best placement for him or her, depending if it would be the community day school or the continuation high school. We'd want to leave up, we'd want to, even in this case of an involuntary transfer, still do right by the student who is the aggressor and figure out where the best placement for that student would be.
Okay.
Madam Chair,
Yes.
and Senator, may I also add, AXA, who came up, is in support, but with a proposed amendment that goes to the heart of some kind of process, or clarifying the process by which that involuntary transfer would take place. We're very much interested. We've been working with them, and we'll continue working with them on that issue. We have no problem with that at all.
Yeah, that would be really good, to be clear, especially for the families that have to deal with it and the administrators, not only in this two district, but others. Last one, will you be able to, and I think you should, make this policy or this expectation clear at the beginning of the year so that parents are aware of what, if something does happen, a lot of time at the beginning of the year, you do parent orientation, blah, 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 just make that policy really clear to students that this could happen if something does go wrong. So that way, I didn't know, it was a total shocker. I think you need to be real clear, because this is very different than most school districts, especially in the rural areas. You need to be clear so that parents know their expectations, especially something this harsh. And I will be supporting it. I just want to make sure that, and I understand your situation. I understand the victims and how difficult it can be, but I want to make sure that the families of the perpetrator actually know their rights and know what their expectations are.
Senator Monning.
Thank you.
Thank you, Madam Chair. So I certainly applaud the objective here and see the dilemma, looking at it through the lens of a student who's been victimized. They shouldn't be further victimized. I do have some concerns, though. We have existing law that absolutely recognizes the right of a student who's been through the juvenile justice system to return to their education. Your bill seeks to accommodate that, but puts the power in the single high school district to enforce that transfer. What I've heard in some of the discussion, and you just referenced it, Senator, is under the current bill formulation, there's kind of no due process or hearing that involves the student who's going to be moved or their parents or guardians. And I've heard you express a willingness to look at that. And I think that would help in terms of placing in this parent involvement, student involvement, maybe some exploration of options. There could be an option that would protect the victim even within that single school district in terms of class assignments and school set schedules that would be less drastic than just an automatic decision to remove. So I'm going to be supportive today, but reserve. I want to see what it looks like when it comes to the Senate floor, and if some of those due process issues might be captured in some future amendments. Thank you.
Thank you. Senator Hancock?
Yeah, thank you. I have many of the same questions, and they were raised in the analysis. So the question would be whether the author is willing to take amendments about a hearing, parental notification. And my question, you did mention the student being unwilling to engage in restorative justice or mediation with the student that was harmed. It seems to me there should be some process like that. Do you have a restorative justice process in your school district?
Like many districts, that's in development for us. At the local site, we take a proactive approach with student discipline, student behavior management. But to say that we have a formal, well-established restorative justice system would be untrue. So
what would be the way of deciding that a student was not amenable to some other kind of counseling or working with them? Because you did say that. And I do feel that if a student is a bully and hurts somebody and doesn't care, the first obligation here is to protect the victim. However, simply making that decision and imposing it, as other members have said, without exploring whether some option that actually would more completely cure the problem. Because one of the things that restorative justice does is it reestablishes the community and really protects the victim.
it does, and we, I think, do an admirable job in our, again, we have a small community. We are very proactive with all of our families. I think we would always explore those options first. This leaves us, should that process not work, if we have continued concerns, this would give us an option to make that removal. In this particular case, we had a student and family that was unwilling to participate in that. We did do some outreach there, and they were not interested, and we had no leverage to be able to say, we need you to do this.
Well, then that's,
Dr. Hancock, if I can just add, in smaller communities, we know all of these students. Every member of the school board knew the boys that were involved in the issue that brought this to our attention, and we knew the families, and our concern was as much for the perpetrator as for the victim. And the fact that we couldn't get him any services and his family wouldn't engage was a primary concern for us. And as Principal Giarmonti mentioned, the idea that we could compel them to engage with us, I think, is part of this issue for us.
Yeah, okay. That may be true in this case, but I don't want to pass a law that would allow a more arbitrary treatment in other rural areas where, honestly, there could be issues of racial and economic disparities and other things. I think you have to write something in that mandates services, counseling, that other things be explored after, otherwise you do have a double jeopardy situation. And it may be true that you have every intention of doing this right because you know everybody. We get told a lot that everybody knows X or Y. You can't make a state law around that. You have to protect from other instances. So,
Senator, I think that's entirely reasonable as part of the work that we're going to be doing with AXA. We'll be looking at that and take your comments to heart on that.
okay, so that I'll vote for the bill today, but I want to be really clear that I'm going to read the bill and read the analysis before voting for it on the floor. I mean, I'm sorry, but I chair public safety, and I hear all the time, DAs know who's a crook. So we do this and that because we can't do this and that. No, we're trying to do something, especially with young people in school, that restores a sense of community. And I appreciate that it would be frustrating if the family didn't want to engage.
Right.
But that's part of our job to find ways to do that.
Right.
I think.
Senator Block. Senator.
Thank you, Madam Chair. I think this is a necessary bill that will, I think, serve us well if properly amended in the vast majority of situations. There's one exception I have in mind. In San Diego County, even though it's an urban county for a large part, in the eastern parts of the county, there are a couple of very remote districts in the mountains that don't have, one is just a one-room schoolhouse. In that situation where you can't force another district, or there's not another school in your district to take the student, does this bill make it compulsory that a neighboring superintendent accept a student? If so, that raises concern. If not, what do we do for the student who has compulsory education?
Senator Block? Senator
I
Walk?
don't, through the chair, I have no answer to that. This bill does not deal with that. We thought, and we'll do more research on how many districts there are like that and see, working with the committee, how can we deal with the safety of that student.
Yeah, I would just address that one issue, and particularly in the very remote districts where even if there is a neighboring district willing to accept, it may be virtually impossible for a student to get to the neighboring school district.
We will look at that.
Thank you.
Thank you. Senator Pan?
Thank you, and I appreciate what you're trying to do, Senator Wolk, in terms of trying to ensure that the victim also has the opportunity to feel safe in their school. But I do have some concern. I do want to clarify, because I wasn't sure, based on the testimony and what I'm hearing from the opposition around restraining orders, because what I thought I heard was there's an implication that a restraining order wouldn't apply in the school. So I wanted to clarify. So, but so we're talking about, we have someone who got convicted of misdemeanor or felony falls in this category, right? And so, of course, one of the mechanisms is for the victim to go pursue a restraining order. Admittedly, the perpetrator has, I presume they're back in school, they've at least completed part of their punishment, right, related to that conviction. So that's why they're now back in school. Why would that mechanism not work? Because that's what the opposition brought up, said, well, the judge would have all the facts because some of the things cannot be disclosed in public, et cetera. So why does the restraining order, or why can't the judge be able to establish a situation that allows, that protects the victim while also, the previous victim, as well as also assures that the youth who's now served the punishment can complete their education. So that part has not been sorted out in my understanding of how that sorts out.
Senator Wolk?
Thank you, and thank you for raising the issue. There is case law on this point. I was disappointed that the analysis didn't go into detail on the two cases that actually are exactly on point on this. And the decision was, I'm not an attorney, but Ezra, Danielle versus Ezra, 2005, in which it was very clearly stated that involuntary transfer is not expulsion or suspension, and in fact, they allowed the transfer even though there was, because there was a TRO, that wasn't sufficient to assure the safety of the victim. So that was permitted, and it's clearly stated in the case law. We need to codify these things. That's why we're back. Came up with a smaller school district. Did you want to? Yeah.
Is it possible to allow the opposition?
They tried.
Public counsel?
So my understanding is that a restraining order would apply to that young person at any time, including at school. So for instance, if it was, staying 1,000 feet away from the victim, that would have to be complied with at any time of day. In addition, there are probation conditions that can be set on either juvenile or adult offenders that can include much more than that. And any violation of that would be possible grounds for being taken back into custody.
Question is how it applies in a small district, and we had that situation. Mr. Germonti.
May I speak to that, or?
Sure.
The restraining orders we've worked with are essentially suspended while at school. I mean, a 1,000-foot restraining order, for example, in a rather small school like ours is simply impossible for a student to comply with. We are not an enforcement agency on those. We can be a reporting agency if we see something that we don't like and feel that law enforcement needs to know. And we also will work with students in those cases to make sure that everybody's on the same page. But some of the mandates of a TRO, we can't do at a school because the student that's subject to the TRO has the right to compulsory public education.
But can also be transferred, but you can't transfer in the size district and 131 others because there's nowhere to go, you know.
That's why it's your
22.
call. So this is a very kind of thorny, this bill does not go to appropriation, just goes to the floor. So, you know, but the author has agreed to continue to work with AXA and the parties involved in trying to resolve this. And I hear from members that you're willing to move the bill so that we can see what kind of amendments come forward that your vote on the floor would be satisfactory or not satisfactory. And I hear that as a commitment from the author of the bill.
It is.
So this is, Senator Vidak has moved the bill. Senator Pan, one more shot.
Well, I will make the same statement, many of my colleagues, is that I appreciate your work on this. Well, I'll support the bill for today, but I think as the chair indicated, I think there's still a lot of work to be done, and that's not a commitment to then vote for it on the floor. I think there's some things I'd like to see addressed, so thank you.
Thank you. Would you like to close?
Yes, I'd like to thank the committee for the discussion. I'd like to thank the chair, and we look forward to continuing to work on those specific issues that have been raised, and we'll certainly work with the chair and the committee.
Thank you very much. Okay, the bill has been moved.
I ask for your aye vote.
Thank you. The bill has been moved. Please call the roll.
This is item number 9, SB 1343. Do pass to the floor. Liu?
Aye.
Liu, aye. Block? Block, aye. Hancock? Huff? Leyva? Leyva, aye. Mendoza? Mendoza, aye. Monning? Monning, aye. Pan? Pan, aye. Vidak? Vidak, aye.
Thank you, Madam Chair and members.
7-0, the bill has sufficient numbers to pass out, but we'll keep the roll open for our absent members. We have Senator Allen in the room, and you have two items